Fair
I'm
enough.
going live. Hello, everyone. Good afternoon. So again, we have Shuchi ma'am in the backstage. Some of you would have met her yesterday. She took a session on transforming your ideas into business, and today she is going to talk about uh, hits and misses in the IP playground. So it will be full of practical case studies, and there'll be literally no theories. So make sure you have your questions ready, and I hope that you'll be able to learn very precise insights on how IPR acts in the real world, like how people use it in the real world. What are the some of the reality checks if you get, which people are not exposed to as students and young innovators, you might get today. So just a little bit about Ms. Shuchi Agarrwal. She's the founder and managing partner of IP Niti, an IP firm based in Noida. She has over 2 decades of experience in the IPR domain and has a robust understanding of the evolution of IPR in India. So, folks, feel free to ask your questions. She's the expert over here. So, while she's instrumental in devising various IP strategies for her clients, she also invests her time in providing end-to-end patent solutions for startups and businesses. So, today I will invite her to talk about hits and misses on the IP playground. Welcome, Shuchi ma'am. The
Thank
stage
you
is
so
yours.
much, Rahul. Thank you so much, Rahul. Thank you for the warm introduction. A very good afternoon to all the viewers and the listeners. I really hope for the people who joined us yesterday, you had a great time the entire day. And I intend to share some insights on the basis of practical case studies as they happen. Through some of the cases that I've put up together, through some of the learnings I would prefer businesses to possibly keep in mind while they strategize their IP requirements, and see how maybe, as and when whatever questions, of course, are there, you're most welcome to stop me and please go ahead with the same. Having said this, I'm going to go ahead and start the presentation. Just checking out if you can see the screen. Is the screen
Yes, we can see the screen, the first
right?
slide. Uh,
Right. Okay. So should I try the slideshow mode? See if that works. Is that visible, Rahul?
the
No.
slideshow, no, it's the same.
All right. So then this is visible, I assume, right?
Yes, the first slide, yeah.
All right. Great. So I'll just
Yeah,
go ahead. Okay.
yeah,
So
it's okay. It's visible at least.
okay. You can see the second slide, right?
The first slide,
Oh, okay. So then now,
yes, the second slide now.
all right. So, what I've tried to focus upon here, and I think statistics are always interesting for all of us, whether it is me, whether it is you. We love to see whether something that we're talking about has any basis to it, right? So, I thought just very quick, some initial slides to talk about. and then take actual case studies with some of the great names of how they have gone ahead and reaped benefit of IPRs, and some case studies where people have failed and what could be the reasons why they failed, so that this could be a learning ground for all of us together. We understand that every year there is no dearth of innovative activity. There is no dearth of entrepreneurship in the world. There are a lot of new businesses that open, so about 100 million new businesses open each year. But if you actually look at the survival rate, it's just a fraction, maybe just 1/10. In fact, from various studies, if I go from one to the other, the failure rate is as high as from 50% to 90%. So basically, we are sure 10% survive, but then from anywhere from 10 to 50% may survive, right? That's a very high rate as to why businesses fail or why startups fail, etc. If we largely look at the challenges why this happens, we're talking about there could be problems with business model, how we structured the business, how we planned, what we did foresee, etc. Or there could be problems where we did not plan for adequate funding, and as we were going along, we found there were more expenses and we did not have capital to meet. There are problems or issues with the product quality, with customer base, and last of all, the thing that gets the attention of the challenge is the legal matter. Now, and of course, the priorities of the business are different, right? The first priority is to make money, to sustain yourself, and then only can you think about after some time profit. So we have to think about a robust business model. We have to hire people who are going to complement the energies that we have, the talents and skill sets that we have. We are always in a rush. Launch the product. We'll take care of, especially if when I talk to a lot of startups and a lot of small companies, budding companies in India, they think मैम सब हो जाएगा, मैम इसको हम कर लेंगे, बस एक बार हम प्रोडक्ट मार्केट में डाल दें. So product launch is one of the biggest exercise. We have to create a market for ourselves and see how much can we contribute to that market. And again, the last priority here is also a legal matter. Now, legal is, by the way, just to explain, a big chunk of which IP is a sub chunk, right? So having set the priorities, let's see how the last priority, which gets the main attention, could actually, if been taken together in the right way, could lead to some of the big hits. So I've put together some case studies of the companies, of how much they've made money, or at least they've made money by focusing on the IP itself. So one is Cisco bought a very, very small company called Power. Not sure how many of you have actually heard about it, but we all understand that the need of the hour is because everything is happening online, right? So we love to share files, we love to share information. We are dependent so much on IT infrastructure. Most of the work, especially during pandemic, we saw was because of the fact that we have internet access, right? So Power actually developed something that they call is a securely share, an app using which you could share, encrypt your files, etc., in a very, very secure manner. This particular this particular solution that Power developed resonated with the wing in Cisco that was dealing with data security solutions. So not very big, but Power got acquired by Cisco. The valuation amount is undisclosed, but it's to the tune of a few hundred millions of dollars. It was just founded in 2004, got acquired in 2015, and one of the bases of the acquisition was the patent that they held. So they had filed, they had planned patents in every single aspect related to the technology that they had developed. As part of it, they had 16 patents, some in India, some in US. The official statement of Cisco says this is a talent and technology acquisition. So mind you, the reason why this was important to highlight is they did not say this is an infrastructural based acquisition. This was a talent and technology acquisition. And of course, whenever we talk about technology acquisition, IP plays a very, very big role. So securing your IP in right time is something that might help you a lot. Another example that I cite is zip dial. We all in India love a few things. So I think very, very initially, when we had this particular charges being imposed for calling or for even receiving calls, etc., there was a point in time when a particular environment had set up. And that was where we would just give a missed call to the other person, and as and when the other person is free would call back, or as and when the other person who possibly had a subscription that was independent on the number of minutes but a monthly thing, they would call back, whatever be the case. So that particular concept of giving a missed call and calling back is something that was being worked further upon. Zip dial, they developed a technology which most of the people now used. If you see the customer care solutions for banks and all, you would see just leave a missed call and we'll call you back, right? Then they tell you the number. The technology essentially that was developed was by ZipDial. This got acquired by Twitter, and they made 40 to 50 million dollars in the way. Imagine the time span of the company. ZipDial was only 6 years. They were founded in 2010, acquired in 2015. They had 6 patents filed in India, US, and Brazil. So not only was this an acquisition of patents, but also of the catchy name ZipDial, which was a trademark. But essentially, though it was a startup and it was small, they took all the right steps to go ahead and secure their IP. And again, this was a technology and brand acquisition. Yet another, if I talk about, is Bajaj Electricals versus Morphy Richards. So when Bajaj Electricals, initially Bajaj Group was more into automotive sector, etc. And when they were trying to expand their business in India, so even big brands or big groups like Bajaj, they felt the need to establish themselves using a reputed brand, which may be international in nature, for the electrical wing. That's where Bajaj Electrical tied up, or they actually took a license to use the mark Morphy Richards in India, because this was established international brand, and they took rights to use the trademark and some of the other trademarks of Morphy Richards in India to promote the electrical goods. Not this only become a big hit, but it was so successful that actually later on Bajaj Electricals renewed their license or extended their license to keep the usage of the mark Morphy Richards with them. So this 100% was the usage of a trademark, which basically meant that the word or the mark Morphy Richards fetch a lot of money to the company by way of this acquisition. The official statement that was being released was, by Bajaj Electricals, the company would be able to leverage its brand positioning in Indian market as well as SAARC countries to further consolidate and gain considerable market share. So we are not talking about technology here. We are talking about the value a trademark can hold and how much it can lead to establishment and promotion of a business. In fact, just by way of licensing, you can make a lot of money out here. Another example that I'd like to cite with respect to another aspect of IPR is copyright. We all have heard about Michael Jackson. A lot of us love the songs. Lot of us love the lyrics, the compositions the guy had created, right? We knew that he died sometime soon, but what most of us wouldn't know is, at the time when he died, he had a debt of $550 million, which is humongous, right? But for the copyright compositions, for the copyright music, lyrics, etc. that he had by way of Beatle musics, that came to the rescue of the guy for his family. And not only the family used those copyrighted work to partly sell it off to Sony Music, etc., or to license it, the company made enough to not only dispose the debt, but they have enough money to now go ahead and just live through that particular licensing money. So 50% of the copyrighted work yet are with the company. Can you imagine? That is the kind of potential, something which is done in a right manner, which is a form of an IP that you protect. It could really, really be a big thing for you. Some of the other case studies is Twitter also took 80 bytes, which is a hugely popular QT platform. And in turn, 80 bits made a lot of money to it. Another acquisition was by Google recently of two IIT students startups, Apture and Katango. This is in the same stream which Google was dealing with. Again, we have two more examples. In fact, Sri M. Iyer, he's a very, very well-known guy. He runs a website called pgurus.com. He's an innovator, an out-of-box thinker. He has about 40 patent applications, granted patents in number of countries, and he's made a lot of money by way of licensing those patents. So if we look at, there are a lot of hits and there are a lot of examples. These are just tiny bits that I've taken together to present before you. You can well imagine that there is a lot of money, there is a lot of business activity that is involved if you plan your ITs and they are done in the right manner. A lot of the times people come back, and if I cite a particular example, they come back and tell me, "Ma'am, ये तो बड़े-बड़े लोग हैं. These are big companies. I mean, we are very small. हमको कौन पूछेगा? And how is it that we can do?" I really wish to cite something here or say something here, which I typically tell my clients. At some point, whether you talk about Gurtej, you talk about Mr. Iyer, you talk about any of these small companies, they were small at some point in time. It is by taking the right steps in the right manner, have they made a lot of money and they've made a name for yourself. So I don't think IP is one field where being a big person or a small person comes into play. It is just the right steps that you take in the direction which will help you build your own assets is going to come handy for you in the future. Some of the misses that I'm going to talk about and possibly spend a little more time with examples, I think would be valuable to the audience, largely because of the fact that I feel that the audience should be able to learn from the lessons that I'm going to talk about in the misses, which are there. Broadly, I have classified the misses as being assumption of IP legalities, lack of paper trail, lack of commercial basis, overt marketing, etc. Let's look at them one by one. Really, what is it that I'm trying to convey? Assumption of IP legalities. The first one is a lot. In fact, I should start this slide with my last line on the slide, which is my creation, my right. Inventors, companies, people who are dealing with the IP channels of the company or the IP works of the companies, they have this particular thing in them. It is my creation, it is my right. Who are you to stop me? Who are you to dictate how I should go ahead and proceed with the same? And that is exactly this attitude that brings in ignorance in IP intricacies. And how is that? So if I talk about, for example, a patent right or a design right, it is not you and I who established the law. You and I are supposed to follow the law that is being set out in this particular respect so that you are the ones who are able to get your IP rights, right? So there is a concept called foreign filing rights. It once happened that I was working with an inventor. This was some years back, maybe around 2010. And I'm not going to name the individual, but this guy had done amazing invention when it came to group reservation system for hotel industry. So there were a lot of platforms available where you could reserve a particular room for yourself, but it was largely for one or two people, but there wasn't good solution available out there for, let's say, a group of 30, 40 people. And accordingly, if one hotel doesn't suffice, then you could have multiple hotels in the vicinity that you could use for reservation, etc. The guy seemingly had developed good solution out of it, worked hard, provided a software solution, etc. And being an Indian guy, he had developed solutions that would work for the Indian market as well as for the US market. Somehow, he felt it was important that he should first go ahead and protect it in the US market because he sees bigger market out there. True to his conviction, he had filed a few patent applications in US, and about 1 year later, he approached me and he said, "Ma'am, I want to file the same now in India. I have already got it drafted. I have somebody who is taking care of it in US, and now I want to go ahead and see if I can get some rights in India." The moment I heard that he's wanting to do this and that he's calling me from Delhi, I happened to chance and ask him, "Did you make these inventions? Were you staying outside India? Were you in US for a while before you actually maybe switched to India, or for some time are you in India?" He said, "No, ma'am, I actually belong to India. I did the inventions here, but just that I felt US is a better market, so I filed it there." I actually had to inform him, much to his dislike, that he had already killed all of his rights. He had actually overlooked an important requirement in the patent law, which says that if you are an Indian inventor and if an invention is created in India, it ought to be first filed in India, or you should seek a foreign filing license or a permit from the Indian Patent Office, that you're free to go ahead and file it directly outside without filing in India. And more important, if you do not follow this, there is civil and criminal liability which is there in the law that is going to act against you. The guy couldn't really believe that what I said was right. But after he, I guess, went through the relevant sections, he understood that he had done a mistake and he had to withdraw the application from US, etc., which led to humongous loss of money, the loss of priority because roughly 11 months had passed, and there was no other option. There was no remedy available to the same. So, because he felt it was his creation and he had the right to decide where to go ahead, he took this step. My creation, my right, sometimes, if not really taken in the right direction, could lead to something that is loss of face, loss of money, and loss of effort. Commercial product exploitation is precursor to IP activity. This I can talk about from the context of a company that was making amazing toys. And really, I mean, if you look at the designs, they were so aesthetically pleasing, etc. They felt that because they're a small company and they want to invest in IP only once they see the product is a success, they went ahead and launched the product in the market. And in fact, a couple of those were very, I would say, functionally great, very compact product toys, and also aesthetically pleasing. Once they found they got good traction from the market, there were enough orders being lined up, and they could see that this could be a success. People have started copying. They wanted to go ahead and protect IP. That was too late for them to go ahead and do anything now about it. Because again, the requirement, whether it is a design protection or a patent protection, which is technical in nature, the technology patents, you are supposed to be making your first disclosure or your first filing before the respective IP office. You cannot in any manner first do a commercial activity and then want to go ahead and file it later on as an IP application. So assumption of IP legalities can be very, very destructive for people. Let your secret out. So I think friendship is something is also, it could be very damaging when it comes to the IP scene. A lot of the times we love to blabber. And this is not in any negative light, but being human beings, we love to tell people, we love to tell our friends, look, I have made something, this is so great. And we love to share what we've done. And even in fact, the curiosity levels amongst people who are well-wishers, they would love to hear what we have done, how great we are, how we are succeeding. And in turn, we end up disclosing a lot of the information, which is really, really meant to be a non-disclosed information or not to be made public till the time an IP right is to be sought. One of the ways of getting out is you should always go ahead and file a non-disclosure agreement, sign a non-disclosure agreement, whether you are sharing your invention, your IP, your design, whatever, whether it is a venture capital, whether it is your friend. In fact, these online chats, a lot of the times, even within the companies, I've had examples where while people are working and then they take a break for a tea or whatever, they end up calling their friends, discussing different things, discussing the project they are involved in, and in turn, they end up sharing some of the valuable information that is absolutely something important for the company, and it may be damaging if at all that is being picked up and it is being enforced someday that the other person knew it, or somebody listens by way of your sharing and starts working. Also, in matters where you are continuously working on something which is going to take some time for you to finalize, especially in technology domain, please consider filing a provisional patent application, because that makes sure or establishes the priority for your technical invention. Lack of paper trail. Again, this was one of the examples that I can quote, having handled this, and I think it was a great learning lesson for the people with whom it happened, for the company, and I think to some extent it was just sad to be a part of this experience, but it was a great learning lesson for all concerned here. There was a company that was dealing with a medical support system. It was one of its kinds, and I think these were young, budding innovators, technical folks who were also trying to set up their own company, which they did later on. And this was a group of friends, three people who came together. And this particular amazing medical support system that they felt they could design, which they did also to a large extent, they started this company, and which happens in a lot of the cases when we talk about small companies or startups, they start off out of some friendships, right? So there was this friendship which did develop, took shape of a company and an initial product offering, which was great technically, which was one of its kind. But the problem that was here was not really technology. The problem here were that there were two friends who felt that they would always be together, come what may. They will stand with each other like anything, and whatever comes tomorrow, they will take it up and solve it themselves. No sooner did they realize after a couple of years that they had a bad fight with them, and the bad fight actually was damaging for the IP they held. They never had any paper trail. They never had any kind of an agreement with them to sort out the inventorship issues, the ownership of the patent, that tomorrow if they end up splitting or if the company gets dissolved, who is going to own what? And it became so murky that they had to not only drop their patents, in fact, this entire thing went down the drain. So something that can be very valuable, not only for you as an inventor or as a developer, but for the world at large, because it was one of the kind of its solutions. It can take a very bad direction, and an IP that you can build and really reap benefits from could just end up being nowhere. False claiming by an insider. A perfect example of this is where if something that you've genuinely put your efforts in, and you are the person who is the genuine creator behind that particular thing, whether it is a logo, whether it is a patent or whatever, if tomorrow somebody happens to steal it and they go ahead and claim that this is theirs and not yours, if you have a proper paper trail being established, there are certain provisions in IP statutes that you could take into account, which can help you reap the ownership, get the ownership back to you, and take it away from people who are falsely wanting to claim themselves as the owner of that IP. Provided all of this can happen if and only if you have a proper paper trail being maintained. Uh, Lack of commercial basics. So partly this delves or it's hand in gloves with the last slide. It's important for us to make sure we understand in the first aspect what kind of agreements are important, whether we are talking about agreements only with outsiders, we are talking about agreements within the company, etc. So I can just put as a guideline, please be very conscious about the number of people you are involved with. As a first step, you can basically understand, if you're running a company, you 100% would have employees, you would have consultants, you would have people from whom you are seeking any services, etc. For every single aspect that you of your business that you are going to be disclosing to one or the other person, please ensure that you have your proper agreements in place. With the employees, you need to have non-disclosure agreements. With your consultants, to the extent that you are sharing the information, they should be protected and the rights should be in the name of the company. Again, when it comes to vendors, please make sure that you have the right people, right legal representatives to reach out to, legal professionals who can help you understand that commercial basics are very important. Another form or another important aspects of agreements are when you're talking about multiple inventors, you're talking about co-applicants, where it should be absolutely clear what kind of an agreement tomorrow, when you talk about exploitation of your IP, would the IP benefits be divided? There has to be a written understanding between the co-founders so that tomorrow, God forbid, but if your company dissolves or if you end up splitting it and parting ways, there is absolutely clear-cut understanding who gets what, and there is no murkiness associated. There are no particular legal suits that you get into, which of course have their own course. A lot of time is wasted, a lot of energy is wasted, and a lot of money, not to say the least. Origin of startup technology or idea during an employment period. This is also another something that I think a lot of the time, especially people who start on their own at some time, at some point in their career, after having worked, after having been associated with a company for a few years. Um, so I could possibly just make it very simple by saying that anyone and everyone who is actually being an employee is employed with a particular company, you would have signed a particular agreement with the company. Please make sure that you read that agreement very, very carefully, because as part of the practice, the company would have a clause in the agreement where it will say any kind of IP that you create during your association with the company is going to vest with the company. So the ownership will lie with the company. And in my practical experience, this is again, this happens numerous times when people develop a new product, they develop a new technology, they develop a new design. In fact, there are times when they develop new logos, absolutely catchy taglines that they develop, and they come back and they say, look, ma'am, I am actually employed with so and so company, but this is something I created outside the office without using office resources, and now this is mine. I would like to protect it in the name, in my name itself. uh, just by not using the resources of the company and assuming you can do it may be a bad idea, because if your agreement says to the contrary, then you wouldn't really have the rights. The ownership will still lie with the company. And you may not be able to file the same, or you may have to disclose this to the company. In some cases, even if you go ahead and file it in your name, the company may have the rights, banking on that agreement, to take it back in their name. So please be very, very careful, and do not assume that whatever is available to you, what you've developed while you were employed with a company, is yours. Overt marketing of products. So I think there is a classic case in this particular regard. Two big names, Rediff and Yahoo, wherein there was a particular algorithm being used by the search platform to sort the results of the search. So when you actually go ahead and type in your keywords, you see certain results that flash on your screen, right, on the page. In the background, there are algorithms being used, which are used to sort the results, the first, second, third, fourth, etc. So, as part of the deal, one company filed a case against the other, saying that, look, you have copied my algorithm, and really, this is not really a right that belongs to you. The other company came back and said this was never a patent in your name because this was already out there in the market. So while the case went on, it was learned that as part of the marketing effort, there was an FAQ page being posted on the website, which actually disclosed part of the algorithm, telling people that, look, we are the best, our algorithm is better, and we are proceeding in XYZ manner. So your overt marketing of your own invention led to cancellation of your patent, which basically meant the company that was trying to enforce the rights lost it because the patent in the first place was held invalid. Be very careful in which form of IP, if it is trademark and copyright. First disclosure of your information in your marketing materials will not hamper your rights. However, if it is design or patents, it can be absolutely damaging for you. Be very careful about the marketing materials, the online content, for any kind of public shows, for any kind of public demonstrations that you intend to go ahead with. Look out for and be very careful that you're not going ahead and disclosing something that you should not as per the IP law. Always consult a person who can, an IP expert who can help you understand to what extent can you make your product or your inventions public. I also feel that this is an important point. There are a lot of incentives, there are a lot of initiatives the government is taking. So while you decide whether you have enough capital or whether it is within your reach to go ahead and file an IP, please do check out a lot of IP incentives, a lot of initiatives the government has taken, so which can help you, assist you in going ahead and filing for your IP, which tomorrow might be a big hit for you, and it can help you make a lot of revenue out of it. Some These were some of the cases that I thought, some learnings that I could share with you as hits and misses, and just a few of my concluding slides. Uh, We understand that 97% of the patents, roughly 95 to 97%, they don't make money. The reason, of course, as I had also elaborated yesterday, it is because either we are not correct, or we are making some mistakes when it comes to legal integrity in intricacies, or we are really not having the right business mindset to take it forward. The idea is, please try and reach out to more people who can help you make your IP a hit. Just by merely filing an IP, it doesn't become a hit. You have to take that business activity. If not yourself, then please do seek external support that can really help you make money out of the IP that you have developed and secured. To give you a statistical breakdown, 60% of the cases that reach the Delhi High Court, 60% of the IP infringement cases which are there in India, they reach the Delhi High Court. And of these, 50% are the ones which are related to trademark infringement, trade secret, and passing off, which essentially means that the courts are also very well versed in dealing with your IP issues. And a lot of the times, and increasingly so, we are seeing trends where IP holders are getting recognition and their dues. Courts are awarding damages. So, if at all there is an impression that we generally tend to have, and especially in a lot of my initial counseling sessions, when people say, "Arey, India mein to kuch nahi hone wala," it might be slow, but it is not that bad. And I think we have to understand, if I talk about from early 2000s when things were very, very slow, today we are really, really much better off. And the damages, the quantum of damages being granted by the courts to IP holders is also great. In fact, the courts are helping with injunctions also, with good damages. It's just about you taking the right steps ahead, and I'm sure you would not be disappointed. My conclusion to all of this is, you should protect your IP well, because if you don't, and if there is ignorance, it just could mean someone else's gain. So why let that be? Let your creation be your gain and no one else's. Thank you so much. With this, I open the session for questions. Can't hear you.
Okay, now it's okay.
Yes,
These
I
are
can
some
hear you now.
statistics and case studies which I think normally people would never, encounter in when they are starting off as IP. And so really great. I mean, is there any, cases where universities have been involved in like disputes with say companies, or if companies are having some, research done in your university? So I have got a lot of questions regarding that. Okay, if some company is funding, and then the inventor, what are their rights and so on if they are in the university? So do you have
Right.
any just shed some light on it, because it's a rather general.
Sure. So I think you were already starting off with my second session on this particular topic, right?
Ah,
So
yes,
this,
yes.
but largely, if I talk about, see, we are talking about external participation or external funding of research projects in universities, right? In India, I would say that the trend for external funding or corporate funding for a particular project is very, very low. But if I talk about Europe, or if I talk about US, there are very, very good funding opportunities which are available for the universities, because of the fact these big corporates do fund for the research and application based research as opposed to just simple research. So yes, there are a lot of problems and a lot of cases. In fact, in a lot of conferences that I go in Europe and US, people do talk about these kind of problems, challenges, and typically the inventorship issues, where assignment by the inventor, who is the core researcher, to the company is typically tedious, or leaking out of information is prevalent. But if I talk about in India, I think such cases are low, possibly because corporate funded research projects are low in India. But there could be certain steps which are preemptive that universities do take, and increasingly, I think the colleges, especially the engineering colleges that we are associated with, acting as their IP cells and all. I think there is a lot of focus by the universities, by the colleges, and to be honest, I should also congratulate the government. Recently, they had come up with national IPR policy, and now they're working on a draft document of guiding the universities of how they could have more industry participation and how they could have very clear cut understanding of the IP rights. So there are different, I think, ownership levels which are being specified. The universities also themselves understand that for them to be more competitive, to have real good researchers being part, because one of the things I think we commonly hear is India mein PhD rate is very low. The number of researchers are very low. People love to research outside, etc. So I think there is a thrust to also increase that kind of research work in India, and hence the innovation, etc. There are ownership issues being sorted out. It is very clearly identified when you talk about ownership, who gets it, on the basis of the resources being used, on the basis of the time being spent, on the basis of funding being used. And I think all of these should be a good step ahead in the next
Mhm.
light.
Yeah, you're right. I mean, the PhDs are the ones who are likely to have innovations uh, and patents and so on that are granted, because other
Right.
students are rather floating population within the academia.
Right.
Given that it takes
Absolutely.
4 years to say even get a grant, and the students
Hmm.
have probably moved on, so they should have some incentive, right there and right then to
Right.
get
Absolutely.
get that out. And
Yeah.
yeah, you're right. It's not very lucrative to do a PhD. So if it's made lucrative to can do a PhD and stick with one thing for 4 years or something like that, that because innovation really is a long term thing, and that is what.
Absolutely, absolutely. And especially when you're talking about finding application to a core research area, not every area is at par, right? Some streams require more research, some less. And then when you're trying to build an application to it, it takes even more effort, more in terms of time, in terms of caliber, in terms of money, right? And being universities, the way the scenario is, they also need enough funds. So I think industry participation to that extent is crucial and a welcome step.
Right.
I think I congratulate the government for taking that kind of step ahead in understanding and acknowledging this problem and finding a solution to it.
Now we have a question from Pranay
Yes,
Singh. Actually, it's very
yes,
it's general, but yeah,
right.
I mean.
Hi, Pranay. So thank you for your question. The question is how to protect intellectual property rights in the innovation process. Um, to be honest, this is a very, very broad question, Pranay, in the sense that nobody can tell you that there is a rule book that you can follow. When you say a innovation process, what technology or what innovation process are we talking about? Are you developing something which is more technical in nature? Are you a designer? Are you working on something which is more aesthetic in nature? Are you someone who is a creator who is possibly playing around with some of the business models? I don't know really what innovation, but let's say we are talking about different technology area. So as you come along in the innovation process, first and the foremost step is for you to understand, have you added anything which is new compared to what was existing? Because any form of IPR requires you to be an innovator, to be a creator of something which is beyond what was existing. And if that be the case, and as an inventor you feel yes, that is the case, you should approach an IP expert, discuss what you've done, how different is that in terms of looks, in terms of technology, in terms of the writing style, I would say, whatever which is your independent and honest creation. And then I think the person should be able to guide you better, understanding all facets, whether it belongs to a patent, a trademark, copyright, design, or maybe it has overlap of different IPRs and you should have multiple rights to it.
There's a form for this session, so please feel free to fill the form. It's in the comment section. So there's a link of Google Forms. It'll help you also stay in touch with IPNITI. So yeah, you can see the forms.gle link in the comment section. So yeah, actually there are some nice comments, very informative,
Thank you so much, Joel.
and Dr. Amit Kumar
Thank you, Dr.
Tiwari.
Tiwari.
Yeah, Dr. Amit Kumar Tiwari, I know he's from Symbiosis. He's the IPR head over there.
All
Can we
right.
have, he has a question. Can we have inventor's name on issued granted certificate for patent?
Okay, so the certificate that you get for a granted patent is the one that the government has made up with. There is a particular format that they follow, and that is what they publish and send it across to you. So there is there's no possibility of changing the particular certificate which is associated with it, but if at all it is required for you to also show that the xyz is the inventor in the particular patent, you could use a particular form which is form 1 associated, which mentions who the inventors of the application are. But to the extent, if the question revolves around can the format be changed, I doubt the same can be done because that's the standard format that the government follows while they issue the certificate to the patent.
Mhm. So feel free to ask any questions, and I think it's the universities who are the main audience that we have, and everyone is fearful of IP. So we have to make some kind of a system where people think that okay, they are they belong here, rather than because universities think that they don't belong.
I think to some extent I see a shift in mindset there.
Mhm.
Um, Partially because of the fact initially I think there was of course less understanding about what IPR is, and anything that we don't typically understand we think it is something big, vital, and let's not just put our hands, we're going to burn our hands. That part is slowly changing on several counts because I think the IP knowledge dissemination is a lot more than what it used to be before. The number of professionals in this particular area, they have increased, right? So which means I'm not going to say this is sufficient because in this diverse and populated country as India, you still have patent agents who are to the tune of let's say 3500 or so. And if I talk about people who are in legal process outsourcing industry along, even we're talking about at best a few tens of thousands, in the sense we're talking about maybe 20, 30,000 people, which is inadequate for the kind of population that we are in. But having said this, are we saying that everything is so difficult? Absolutely not. If you really look at the online filing system is a great boost. Nobody could imagine that in India we can get a trademark certificate in 6 months. I mean, till few years back it's such a welcome change for the IP office that you can now file. The examination procedure is so streamlined, and we ourselves in our inboxes, as soon as the time period matures, we have a certificate. We could never imagine a patent being granted in 8 to 9 months, and that is the case today. So I think yes, there are a lot of heartening improvements if I talk about an IP industry. There is also this national ranking system for universities where I think now one of the parameters which is there is for the universities to go ahead and have more IP created to them. So I think these kind of incentives will also help as great levelers for the universities, helping universities which are even publicly funded, giving them the right to reach out to people and have an option of reassignment where the university doesn't see that they are going to make money out of it, and let people go ahead and exploit the invention or have co-exploitation rights. I think these are some very good measures that should in the long run be very helpful for the Indian universities in coming along.
Yeah, we have a question.
Sure.
Miss
Preeti.
Preeti.
Yeah. Hi, Preeti. The question is before the filing of a complete specification, when inventors intend to change claims, can one make a broader claim? Okay. So, when you say before filing of a complete specification, my first assumption is that you've made a provisional application, right? And then when you make a provisional application, the provisional application is not a hardline document where the claims which are there are the final treated claims. They are the claims which, if at all you put with provisional, they are guidelines to basically set out the scope. So, therefore, you can, when you submit your complete specification, you absolutely add more enablement details to your invention. And at the same time, you can work around the claims and add material which is the subject matter of your provisional application. The only thing that you have to keep in mind is if your subject matter of non-provisional application was not covered in your provisional application, then the priority date for that particular material of your non-provisional is going to shift to the date of filing of your complete. Otherwise, you're good to go. You can make the claim changes and file a complete application, and your priority would remain the provisional if said subject matter was part of your provisional application. I hope that helps.
By the way, Shuchi ma'am will be there also after lunch. So we are having a lunch break from 1 to 2 p.m. And Shuchi ma'am and Ms. Mansi Chaudhry, they are together going to have a panel discussion on how to boost IP filing in academia. So I will myself be the moderator, and I'm really looking forward to that session because there are some questions that I have, that I think will bring out some insights that the audience will be really looking to. And if you want to get in touch with her, please see this banner that you see on the live stream, email at ipneeti.com. So let's see if we are ready to take some last maybe 1 or 2 questions. Otherwise, the stream is going to keep running throughout lunch. We will play some videos at the end, and we will share some information. So throughout lunch, I or one of my team members will be there on the stream. And okay, Preeti is saying thank you, and Dr. Amit Tiwari is saying thank you.
My pleasure. My pleasure.
Great. So thank you, ma'am. That was really a nice session. And we will see you at 2 p.m. And meanwhile,
Absolutely.
The audience, they can stay, they can, see the other information that we will share. And see you also at 2 p.m.
Sure. Thank you so much, Rahul. Thank you so much, audience.
Thank you. Bye-bye.
Bye.
Folks, we will break for lunch. I will put the lunch banner, and I will actually, before breaking, I will show you a couple of videos that actually IP Neeti has made. It's really nice videos. I think you will enjoy. And after the videos, and what we are in for in the next half of the day, we have some really compelling sessions, folks. Don't miss out. I will actually send out one more email in half an hour time that it's not over. TIF 2021, it's not over by Good afternoon, everyone. Welcome to the most awaited panel discussion of TIF 2021. So good to have you back. We have with us two very successful patent attorneys with us who are going to join us. They are backstage and I will soon invite them. Ms. Shuchi Agarrwal, she is the founder and managing partner of IP Niti. Some of you might have already attended some of her sessions. And Ms. Mansi Chaudhry, she is also the founder and managing partner of the Frontiers Legal. So, folks, this session has been, put together so that we, with the aim of inspiring young innovators and also all the stakeholders in academia who, together might come together to boost the IP filings in India. It is a very hot topic. There is a lot of talk about IP filing boosting. There is a lot of government support. There is a lot of action. Okay, and this is what we wish to get it together. So with this, I would like to invite first Ms. Shuchi Agarrwal.
Thank you so much.
Welcome, ma'am. Welcome. We will soon invite Ms. Mansi Chaudhry also. Just I want to check if her video is working. Uh, okay, ma'am. I think we can start, and we will soon have Mansi Chaudhry also. Yeah, we are. I think she's here. She's here, but her mic is not muted. Her mic is muted.
All
Your
right.
mic. Yeah,
Fine now?
great.
Okay.
Great,
Thank you.
great to have you both. Really, I'm really looking forward to the session, and I hope the audience is too. Please feel free to ask questions in real time because in this session we don't have slides, which is a very refreshing thing after almost 2 days of sessions. And we will highlight, and I'll try to make sure that we can take them right away. So, Shuchi ma'am, I'd like to start with you a little bit about your journey because I think the journey itself is something that people should know and listen and feel inspired. That how someone pursues an IP journey in India and what's in it for them. To have some takeaways. So please, if you could shed some light.
Sure, absolutely. Thank you once again, Rahul, for inviting me for this panel discussion. I think I'm enjoying every single session, whether it is my session or other sessions. Great information being disclosed. Thank you so much, audience, for staying with us and for your patient hearing. We hope you do enjoy this session as well. Yes, if I talk about my IP journey, if I be very honest, this is just by chance. Okay. This wasn't something that I had planned. In fact, if I talk about early 2000s, this was an era where the only thing that people understood, especially in technology area, is how to become a software engineer, how to get into a job that's going to give them some coding expertise or some sort of IT related job. That is all. So even in colleges, this used to be a fancy thing that you're being recruited, etc. Also, amazing time when I graduated was the time when we had this slump where we had this problem that all of a sudden Y2K problem occurred, and there were not too many jobs. In fact, people there was great recession. People were asked to leave. So I think amidst this particular turmoil of doing engineering, so by the way, I'm bioacademically electronics telecommunication engineer, and then I specialized in VLSI post my engineering. But it was still challenging to understand what is it that I could do. If I talk about my personal thing, the only thing that I disliked at that point in time, which everyone was crazy about, I don't want to get into any IT related job. I don't want to be sitting on the desk and doing coding. But what next is something I was clueless. And I'm sure I'm not the only individual at that particular point in time, at that stage in your life, who is clueless. A lot of the people are. But at least I knew I was clueless. And the next thing that I knew, I don't want to do anything which talks about getting vertical into the technology because I don't think I'm meant for it. That's not my cut. But I love to read technologies. I love to understand them. I love to see what can be done creatively by intermixing them, etc. That was the only thing that was clear in my mind. And with this aim of finding something that's going to expose me to different technologies, I started looking out. And I think doing that, something that popped to me was that there was an opening in IPRs, okay, And when I heard that IPRs, first I understood this is legal. But then when I saw engineers are required, I mean, I was equally clueless. Mind you, I didn't know what IPRs are. I had heard there is something called patents, there's trademarks, etc. And I think I tried pursuing it. First, I read upon it what it is, and it felt like something that I could try my hands on. That is what took me to the IPR industry. I worked for a couple of years with a reputed law firm in India, which largely deals with patent filings and patent prosecution in India, patent litigation in India. And within a couple of months, I realized that in 2 months, I've already worked on cases which were talking about 6, 7 different technologies. And I think that particular thing of from being clueless to having some clue started in my mind. So I felt this may be the thing I should look out for and work more. As and when I started understanding the nature of it, and I worked on different projects, I realized this is interesting, and this kicked in because anything and everything could have a completely different interpretation. As technology, as legal, as technical people, we understand if we are talking about fabrication, it means fabrication. If we are talking about a sensor, we're talking about a sensor. But then when we are asked to interpret the same terms, looking at specifications which can redefine the meaning of those, that is challenging, that is intriguing, but that is also something that I think I loved. It completely exposed to me in a completely new world where different things could have different meanings, different things to it associated. I think from there my journey started. Slowly, then I understood that what legality in technology meant. Uh, After having worked there, then I thought this was one chunk, but I'm sure there's a lot more before I finalize. This is where I want to have my career in. And I went into, I changed job. I was in a second company, which largely dealt with US and European patent practice. So these are typically called legal process outsourcing related work that we do, and there are a lot of LPOs in India. I joined them, worked with them for a few years, got to interact with a lot of US attorneys, European attorneys, and I learned different facets for the same thing that I was doing in India. And I mind you, so if I'm doing a patent draft in India, there is a particular perspective that we are sharing. The same thing when I work with US attorney or I work with European attorney, it has a completely different perspective. It is the same technology, different perspective, and I think I really enjoyed these different things. That set finally in my mind that yes, this is the place where I'm going to make my career. Thereafter, I took a break, went back to academics, did my master's in intellectual property and competition laws to understand these different spots, the two dots that I had by way of two companies and the different prosecutions, different ways of how IPs interplay. I wanted to get a stronghold. I went for my master's outside India. As part of it, I also did my internship in Intel in Europe, came back to India for a very small bit, worked with another very leading corporate law firm in India who were wanting to establish their patent division here in Delhi. And then I thought, yes, there's some exposure I have when I talk about profession. There is some exposure that I have when it comes to academics. And I wanted to put all of this together and see how I can now personally contribute to the IP scene in India. And I think that's where exactly IP Niti started some 7, 8 years back. And I'm happy to share that our journey has been nice. It has been challenging, but it has been inspiring also at times. It has been high, but it has had its own lows. But overall, I think it has been an experience, and it brings cheer, not only a smile, but it really brings a cheer when you work with individuals, groom them, when you work with academics, when you work with companies, and you're able to give them a direction that they're seeking for. And it, of course, at the end of it, it produces business for them in terms of commercial exploitation. So yes, I think this has been a great journey so far.
Incredible, incredible, absolutely. Thank you so much. Thank you so much. Mansi, I mean, a little bit, in the same way about you, and I also think you have been this WOS Women of Science Scholarship from TIFAC. So also, if you can shed some light on that, so that people who are in this in the audience, they can also learn, what might be what they have in for,
Okay. Okay. Thank you. First of all, thank you very much for inviting me for this panel discussion. And having here, to met Suchi for the first time, and it's been
Same
really
here.
great to share the panel with her. So, if I'll talk about the Women Scientist Scholarship Scheme, which is being granted by Department of Science and Technology, Government of India. So, I actually started my career in IP through that scholarship scheme only. So soon after my masters, I came to know during my masters, when I was doing my masters, I came to know about this scholarship scheme, which is being granted by Department of Science and Technology. So there's an autonomous organization which comes under Department of Science and Technology by the name with TIFAC in short we call it. So it's a Technology Information Forecasting Assessment Council, which is an autonomous body set up under Department of Science and Technology. So there's a patent facilitating center under the which is under the TIFAC, which actually provide patent facilitation to different organizations, to different universities, even to inventors all over India. They have different patent information centers with different. They have a setup by the name of patent information centers with different states. So basically, the PFC PFC, the Patent Facilitation Center, it is actually conducting the Women Scientist Scholarship Exam, which is in the area of IPR. So it's a scheme to empower women who are actually from the science stream and there's some kind of gap in their career and because of any reason they could not pursue, uh, you know, um, the science field, the field further to be in the domain. So this actually the scholarship provides opportunity to those kind of women to empower them and to train them in the area of intellectual property rights especially. It could be trademark, it could be copyright, it could be patents. So, but since the background, the requirement for the scholarship is basically the science requirement. So most of the women scientists are the registered patent agents now, and they are into the area of patents. So you will be surprised to know that about 10% of the total number of registered patent agents, the 10% of that, around 10% of that is from this women scientist scholarship scheme. So basically, from the scholarship scheme, right now there are around 800, about 800 women who have been trained by Government of India under this scholarship scheme, and around, out of 800, around about 300 women scientists have cleared the registered patent agent, and they have a successful career as well. Many of them have started their own organization, just like I'm one of them. I have also set up, very recently, I've set up my own organization. So basically, this kind of a scholarship is giving a lot of opportunities to the women in our country, and specifically in such an area, which is, I mean, IPR is not, which is, not many people are really aware of this area. So it's actually creating a pool of women scientists in this particular area, and the women are doing really good. So I also started. I took off on this field. I also started with the scholarship scheme, and the scholarship is it is a very different kind of a scholarship, unlike the other scholarship schemes of Department of Science and Technology because of the reason that they provide job term training. So they provide the practical hand-on to experience the different intellectual property rights. So they associate you with different agencies. It could be a law firm. It could be the LPOs. It could be the scientific organization where you can do research on IPR. And that's a practical. It's a 1 year. The duration for the scholarship program is 1 year, and we provide 1 month orientation program, which is a full classroom program. The experts from all over India, even from abroad, they teach you, they provide you all sort of information related to the field. And then for another 11 months, they associate you with different agencies so that you can have a practical experience for the field. So I also started with this. Um, Very much like Suchi, I've also, I'm from the biotech. I have a biotechnology background. I never had an interest in research as such, but at the same time, I always wanted. I have a love for science, so I always wanted to be connected with the field. I was looking for some area where I will be in touch with the science also, but I really wanted to do something which is different, which is not a hardcore like at least after completing your master you go ahead to do your PhD. I was never interested in that. So accidentally, when I was doing my master, one of our teacher, he asked the students to attend one of the workshops, which somehow I missed for some reasons. And as a punishment, because he was one of the strict teachers we had. So as a punishment, he gave me a presentation which was one of the difficult one, and I've never heard about it, which was a patenting in biotechnology. So I've never heard that word in my life, you know. So that was, but somehow when I was preparing the presentation, somehow, you know, I got connected with it. I just get that kind of exposure that this is something field where I can be connected with the science at the same time. I'm not doing the hardcore wet lab work or the
Yes.
research work in the labs doing the experiments and all those things in the lab, that I was not a kind of a person. I was the one who was always skipping the practicals in the classes. I've always bunked the practical classes for the reason because somehow I never had that kind of I never had that kind of bent. So from there, it all started. I started searching out, and then I came to know about the scholarship scheme. And fortunately, I cleared that scholarship scheme. And soon after that, I was associated with one of the premier law firm of India. I worked with them for around 7, 8 years, and then I joined another two firms. So, and I have a strong, strong background in dealing with the patent prosecution. Throughout, in all the three firms, I have worked in the patent prosecution department. I've handled major portfolios overseas. I've handled basically the foreign renewal applications, even the foreign prosecutions in almost in each and every country of the world. I handle quite a big portfolio of foreign patent applications. So I worked for one of the biggest filers of patent for the Council of Scientific and Industrial Research. I've handled the complete patent portfolio in the firm for overseas patent filing and prosecution. So that's how the journey started. And few years back, just for some reasons, I set up my own organization by the name of Frontiers Legal, and I'm happy that what I'm doing now, I'm taking up a lot more. Working in some organization is a different kind of an experience, and when you start your own, it's entirely different because you have to manage each and everything, right from the scratch to everything. Like now, I'm doing everything right from the filing to the prosecution, even the commercialization aspect, licensing, making the agreements, everything. So it's different. I'm enjoying it. I'm really loving it. So this is all about how it all started. And
Awesome. Really, really nice. So just to clarify one thing, in the pre-event, you were showing that there were like 4,000 patent attorneys, not patent attorneys, registered patent agents in
patent
India
agents.
in
Yeah,
the website. So, and you in the beginning, you said that 10% are from the Women of Science Scholarship. Is it?
around it's about 10%. Yes,
Okay, okay. So,
that's
okay,
very true.
quite
That's very
interesting.
true. Yeah.
So, and Shuchi, you were also saying some statistics.
Once again, I think there is a question. Maybe we can first respond to that. So, as and when we have
Yeah,
questions, we could attend to them and then
yes.
continue with the session, right?
Dr. Chetan Kumar
Yeah,
Patel.
right. So, Dr. Patel
So,
is actually asked, I would like to know what is first examination report, second examination report, and what is the situation where we need to go for the hearing, right? Uh, Dr. Patel, basically, whenever you file an application before the Indian Patent Office, or for that matter, any patent office across the globe, there is an examination that the patent office conducts to understand whether they need to give you a patent on the basis of the legal criteria laid out in the Act. So the criteria are also defined, which largely are inventive step, novelty, industrial application, specification requirements, or in India, non-patentability requirements. In order to do that kind of examination, they come across some prior arts. They find that there are certain things which need to be complied to if they are legal in nature, and they issue a report which is in writing, which is called as a first examination report. If that be the first report that is being issued, that's called a first examination report. In very few cases, Indian Patent Office issues a second examination report. And for all of these reports which you receive from the Patent Office, you're supposed to furnish a written reply to attend to the same. And then thereafter, if the examiner is still not satisfied with the response that the applicant furnishes, they call for a hearing, which is a face-to-face hearing. But now, since pandemic has started, largely everything is now online, and there is a video conference that takes place, and you have to respond by way of the hearing, attend the hearing with the controller, explain why you feel that there is a merit in the invention that you have, and come up with the differences from the citations that the examiner has given, and accordingly the decision post the hearing comes up. I hope I've been able to respond to your question.
Actually, we have a question from Gargi also. If either Shuchi or either Mansi, if you can see this, which funding agencies she can reach if she has to submit a proposal on IPR?
Okay.
Sure.
Okay. So the question is being asked by Gagi that I want to submit project proposal on IPR. Can you please say where I can submit my project and who are the funding agencies? All right. So basically, the project proposals can be submitted, to any government agencies. If you want to specifically, if I'll talk about any specific agency, then we have Department of Science and Technology, we have Department of Biotechnology. Department of Science and Technology supports all kind of, provide support to all kind of technologies. Department of Biotechnology is particularly for the biotechnology applications. Apart from that, there are other government agencies also. Like if 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 I'll talk about the funding agencies, then we have NRDC also. They provide funding for filing the patent applications and for the prosecution purposes also. Even for the technology transfer also. The NRDC provided great support, great funding support. Then there are other funding agencies. If I'll talk about if your project is related to the biotechnology, then BIOTech is one body which comes under the Department of Biotechnology. They have many grant. They provide many fundings to the projects at different levels, specifically for the IPR generation. So, like that, you can apply to any agency where you feel, where your IPR proposals can be considered. Because most of the agencies now, the government agencies are now considering and they are providing funds specifically when they are when they are providing grant for the project. So there's a specific, the proportion in that grant which is particularly for the intellectual property support. So likewise, you can, submit your proposal with any of the government agencies you would like to have. You can look for you can go through their websites. So the particular specifications about the proposals you can get from there.
Absolutely.
Actually,
And
yeah,
just
yeah,
one
yeah,
thing to
please.
add to, absolutely well elaborated by Mansi. There are, in fact, if you just do a basic search on Google, you would find that there are different websites by the government where they've even listed out which are the other agencies that you can reach out to. And there are also links directly that you can
Right.
access to submit your proposals.
Right. So actually, Sri Kumar has asked a question which I had in mind for the later half, because it is related now to one of IP boosting thing that to boost IP filing, collaboration is really one bullet point. If I have to
Right.
think of many bullet points, so could
Right.
you please shed some light on this question so
Sure.
that it covers that part?
Sure, absolutely. So yeah, I'll just read out the question for the benefit of the audience. Shri Kumar has asked, related to IPR and collaboration projects, for example, that is collaboration with industry, government, or other institutions, what should be the collaboration policy? So, number one, would it be safe to assume that you're talking about collaboration of academics with industry or government or an individual? But I think largely, if we talk about collaboration of any nature, especially in IP collaboration, there are certain things that you should keep in mind, which are the key issues to be addressed, and accordingly, then you can look out what is the better source for you to collaborate with. The issues largely to be kept in mind is about the funding part of it. Who is the one who is going to be funding? Whether both the people who are coming together are going to be doing part funding or the entire. Who retains the ownership? So maybe when you are trying to negotiate collaboration, it is very, very important for you to understand if you are going to be the owner of the IP rights, or if the other person is going to be the owner, or are you guys going to be co-owners, and you decide out a particular percentage divide of any benefit sharing tomorrow, or any kind of commercial activity that comes out by way of a successful launch of a product or service. How would you be approaching to the same? Then we are talking about who's going to be managing the entire IP in such collaborative projects. whether both of you agree or both of you have distinct expertise which you complement with each other. So one person chips in for one kind of expertise, the other one brings in another kind of expertise, and together you make a successful team. What would be the research procedures involved? What are going to be the benchmarks in terms of the timings? Whether both the parties, or if one of the party is very very privy and has understanding of IP, and what different disclosure requirements are, what different contribution assessments are, who is going to be taking care of the filing for the prosecution of the same, the caveats, if there is any conflict of interest, the terms that you decide, whether both of you agree to that or not. And then, lastly but not the less, basically, who is going to be bringing on the infrastructure to that? Infrastructure is diverse here. We are not only talking about capital, we are talking about labs, we are talking about machinery, we are talking about expertise. So, whether it is go together, both of you are chipping in, or whether it is going to be one. So that's how it is. I think a lot of factors that need to be evaluated. And then accordingly, once you find what your strengths are, which is always the case before you should go for negotiation, having your strengths, then you judge amongst the external party, the industry, government, or institution, who is the one who is able to complement you better for what is missing out from your end. That will be my 2 cents.
Yeah, yeah. Do you have anything to say, Mansi? Like, I think you were mentioning, or Shuchi was mentioning about some examples from foreign universities who have collaborated and they have got really good results.
See, the collaboration, if I talk about particularly, so first of all, it was very well explained by Suchi. So everything is covered up. We generally have in the collaboration policy, if I'll talk about, the ownership is a very big issue. So that was quite it was elaborated by Shuchi very well. Then, if I talk about the collaboration policy in India, we actually, the kind of an agreement which need to be made between the applicants, or between the inventors. So those things really matters of what kind of agreement they have. It could be related to the infrastructure, yes, of course, which was explained by Suchi, like the labs, from where the materials have been procured, what kind of experiments have to be conducted. So a proper consensus need to be required, and all those things need to be there in the policy in a with a very clear terms and conditions. So those kind of things. In India, unfortunately, we don't have very collaboration, the collaborative kind of system. We don't have. But there are if I quote one big example of the collaboration research, where the very good results have been obtained. So, one good institute which I'll name as a very good example, if I have to give for that, is a Broad Institute. The Broad Institute is an institute where many universities, like big universities or institutes, they come in collaboration with each other. Uh, so the examples are, for the Broad Institute, the collaboration is between the Harvard University with the MIT, and with the different hospitals which comes under the Harvard University. So what happened, the kind of a collaborative research they have is like they collaborate, the university provides the students, the research, the faculty are getting involved with the MIT, with the Technology Institute, and like for the experimentation purpose, they use the different hospitals or the different research labs which are set up particularly for conducting the research. So that kind of a collaborative research, it really works, but the proper policies and the proper clear checks should be there. We don't have, so the Broad Institute is one of the very successful example in terms of that. They have a big patent portfolio, and they have a very good funding which they have generated out of doing the IP commercialization through their patents. So that one very good example if I have to quote for that.
Yeah, thank you. We have a question from Amita Agarwal that if you can please take it, Shuchi. I think it's
Sure.
about collaboration, and then she has a specific question about who will be the inventor.
Sure. So maybe I could just read out the question. So Amita has asked, being from medical background, if I have an idea, and engineering department of same institute are helpful for designing same idea or equipment, is it a collaboration? And in such case, who will be the inventor? So, first and the foremost, when I respond, there are certain assumptions I'm taking to this question. So, my assumption is that you are part of that engineering department of the institute, and maybe you are one of the researcher to that particular department. and therefore you've designed your solution uh, using the facilities of the institute or of the department, right? Now, see, largely, as a first point, I don't know if that happened in your case or not, but you may have a agreement with, you may have signed a particular agreement with the university before taking your research, that if you are making something, you should check out those clauses, right? So one of the clause could be that if you're developing something using the resources of the university, then the ownership of that may vest with the university, or it could be the joint ownership between you and the university. So I think it's important for us to see if you already have a prior established ownership clause or if you don't. Let's assume if you do, then in that case, you will have to go by as your binding agreement is. But in case if you are not there, then I think in terms of applicant right, you will have to speak to the relevant person who could be the applicant. But with respect to inventorship, you are the one who has come up with the invention. So certainly you would be identified as the inventor for that particular application if you happen to file one.
Right, right. Yeah, hope Amita, that answers your question. Taking the discussion forward, we will still wait for your comments. As soon as you have comments, we can, interrupt ourselves and, put them here. Mansi, you are an alumni from Amity University, if I'm not wrong.
Yes.
And recently there's a lot of boost in the number of filings and all. So
Yes.
is that a success story? And if yes, how they achieved it, and what are the things they did right?
Yes. So if I'll talk about Amity University, I have seen they have the Amity University particularly started in the year 2003. I've joined that university in the year 2005. I was a part of a department where I've just did my master's program. So where there was a lot of focus on the research area. So particularly if I talk about Amity University setup, that what kind of things they have incorporated in their campus and how they have motivated their students to conduct more and more research is one of the biggest examples because I have witnessed all that. The main focus in Amity is on research part when you are whether you are a bachelor, whether you are doing the bachelor's degree or you are doing the master program. There's a specific focus on the research, and of course, if I talk about the patent system, uh, in the starting in the year 2003 or 2005 when I've joined. Earlier, yes, the focus was on the publication, but they realized at a very early stage that what the patent system will contribute to the growth of the university, how it will improve their ranking, and how it will contribute to the society also for the benefits of the patent system, and how it will give a boost to the students' knowledge as well. So they have identified that at a very early stage. They had a setup. They set a department, which was the patent department, particularly the IP department, where there was a lot of focus on the workshops, conducting the workshops and the seminars, and different, at a very grand level, they have started with this off. So it is what I have witnessed, what I have seen over there is it was one of the university who was aggressive towards their approach to file patents, and they have achieved in a very short span. So that's a very good example to other universities. They have set a very good example to other universities, and being a private university, they have secured so many grants from from different government institutes or the private institutes. They have very good collaboration with the private institutes, research institute, and they send their students there. Even when I was in my master's program, they have a collaboration with different universities to give us different kind of lectures to conduct various research projects. So that kind of the atmosphere, the ecosystem the Amity has created for its students, and that resulted in a maximum number of patent filings. So of course, it is one of the biggest academic example in terms of the maximum number of patent filings. Apart from that, they have a technology transfer cell also now, which is quite active. So it's not just that they are filing the patents; they are commercializing it very aggressively. Also, they have the incubation center as well, They have, even with NRDC, they have set up a different innovation under a specific innovation program of NRDC. The NRDC has set up one of the center, which is NRDC has actually set up three that kind of under that program. NRDC has six collaboration with six universities, and one of them is Amity University. So it is one of the, yes, one of the biggest example in terms of academic services and towards approaching towards IP filing. So it is one of the biggest examples.
Excellent, excellent. Shuchi, do you have any couple of success stories that you know from technology transfer, or not technology transfer, but academic, IP filings?
Sure, absolutely. So I think like Mansi was just talking about Amity, I could talk about a few examples of the success stories of technology transfer by Amity. So in fact, they've commercialized a technology by the name Rootonic, which basically promotes agriculture, horticulture, and forest productivity. And there is some magic fungus for which they have a particular patent to go ahead with of how productivity could be increased. There are a lot of other inventions from them, like herbal mosquito repellent or a fly ash battery, which was very, very successfully commercialized. And there were private players who not only took the license, but they're also now manufacturing the product and selling it. Another example that comes to my mind is by Sri Chitra Institute. So this is basically out in South in Trichy. They actually have commercialized recently, just in Jan 2021 itself, two of their technologies in medical devices area. So there is a flow diverter and an occluder that they had developed, for which they partnered with Biorad Medicis, who have taken license for the two technologies available. One is for plugging the hole in the heart, and the other one is a flow diverter. Both have found successful implementations, and it is supposed to be one of the most low-cost device which would be available in the market once it's being launched. It's right now under development production phase. So, in fact, if I talk about IITs, and I think my first exposure to IIT in terms of building patents was when I actually initially joined this particular field. The the FITT cell, which is the cell which deals with IP activities in IIT, they are also very vigilant, and they try their best to go ahead and commercialize. As much as I'm aware of, that IIT Delhi itself has commercialized 15 of its patents, and they've partnered with companies who are producing who are manufacturing the products, and there are successful launch of the same in the market. So if I talk about in India, I think I would say that there are success stories in India about technology commercialization, of IP commercialization, especially patents. But is that number sufficient enough if I talk about from in comparison with the universities outside India? May not be. But let's also understand, which I think is a very, very big factor for us to understand, India is still in the maturing phase of IP, in the sense that if I talk about, everything is relative. When I entered this field, people really didn't understand what IPR is. To be honest, if I would tell people that I'm in the field of intellectual property, the next response used to be really nice. They would say, "Oh, acha, aap property ka kaam karti hain." People really didn't feel there was anything called intellectual property. From that stage, with the help of the government and private effort, the knowledge dissemination has been proportional. People now understand to a point where we've reached, where there's this startup eco culture, where people think, "Acha, ye maine socha, iska pehle main IP karwa lu." So we are getting there. We still are not at the best level, but I think we are taking steps where we are getting. Technologies commercialization in last few years has picked up at academic level, and I think in next 2-3 years we'll see long run where there'll be much better stories coming out, because even institutes, academics, universities themselves, I am basically working with a few colleges themselves, very keen on now no more just taking a patent, filing it, getting a grant and having a certificate. They are actively looking for channel partners. They have put up their technologies for commercialization. And I think, yes, also somewhere the industry funding has come up, or people are opening up to Indian universities where they can, at least for some base level research, they could partner with universities and see if they can take this up. So I do see some good pictures, some silver lining in the cloud.
Mhm. Oh, excellent, excellent. And
I think we have a few questions.
yeah, we can take this. So, Jyoti Prakash Dutt, is it possible to revoke a patent? So, if you want to take a crack at it,
Maybe
Mansi.
Mansi?
Yes, of course. It is possible to revoke a patent. So the simple answer to your question is yes, it is possible to revoke a patent. You can revoke, there are many grounds, or on the basis of that, you can revoke a patent. So I'm not going into the details of what all grounds are because that would be a very lengthy thing to explain here. So
Mhm,
yes, we have provisions under law where there are specific grounds on the basis of that you can revoke a patent.
mhm.
So yes,
So yeah. So Mansi, in your pre-event also you were talking about the patent agent exam, and as such, do you think that there is a need for uh, more IP expertise, not just say as a career? Should people in academics think about IP as a career? And given the fact that we might witness a brisk growth of IP filings, so how does it stack up? What are the key skills? And whether the 4,000 number you said, is it like enough? Do we need more, or how is it?
of course not. It's a very less number because it's not
It's
just
less.
we have around 4,000 registered patent agents now, and all are not active. Out of even
Right.
4,000, I'll say roughly, if I'll talk about that, even 50 to 60% agents are active actually, and at different levels. So the expertise comes with with the number of years of experience, and what kind of exposure you have. Like in IP, the domain is not just the one is having. We can have the registered patent agents can have different kind of exposures to the work, different kind of work when you are working with some organization. Like some are just associated with the patent prosecution, some are into the at the enforcement stage where they are just doing the opposition work or where they're just handling the litigation work. So that's how the expertise built up with the years of experience in this particular field. So yes, of course, there's a big need actually with a lot of innovations are now coming up, and we are actually moving ahead with strong IP regimes. The government is vigilantly working on it. We have new policies, so with that, yes, of course, there's a need arises that a lot of institutes, and the one thing which where we are still lacking is of course, awareness is still not at that level where the everybody is aware of. Still, the problem is that, as the Suchi has mentioned, that if you talk about if you tell somebody that you are in intellectual, you are a patent attorney, so the first question they will ask you, if I say to someone that I've started a law firm, so the first question they said, law कब किया? तुमने तो मास्टर्स किया था साइंस में. Law कब किया? So are you practicing with the court? So that understanding, and it's not just that you're getting that question from someone who is not even aware of that. It's just that question can come up from anywhere. Even I've seen many scientists also from at different levels. They can ask you this question, there's no clarity still, they are confused between what is trademark, what is copyright, what is patent. Generally the
Yeah.
inventors come to us and they ask us कि मैम एक आइडिया है, क्या इसको हम कॉपीराइट करा सकते हैं? हमारी इन्वेंशन है, क्या हम इसको कॉपीराइट करा सकते हैं? क्या हम इसको
Hmm.
ट्रेडमार्क करा सकते हैं? So we have, that those kind of things, so proper awareness is not there.
Yeah.
Even the government is taking a lot of steps, but still it is, I think it is not reaching to a level where they have to particularly they can they can find out the difference, exact difference what is there in the different IP forms. So that is of course lacking. So that's why we really need manpower. We need more agents. We need more experienced people in this field so that they can guide the academics and different inventors on the different levels, different institutes.
Right,
So
right. So actually, on this topic, there's a question: if you have any recommendations of uh, institutions or courses on IPR, Jyoti Prakash Rath. So Shuchi, if you want to take it.
Sure. Sure. So there are quite a few available out there, both if you want free courseware as well as if you want to actually take classes. There's a lot of material available from IGNOU. They have a lot of free material. which they give access to, and there are good courseware that you can refer to. There's a specific organization, WIPO, which is called WIPO. There is a lot of material out there on IPR, from basics to little advanced. They also have courses that they conduct, which are short term courses to long term courses. They may be helpful for you. Plus, in India, you have National Law University and all. Mostly, all of these people, Indian Law Institute, etc., they have their proper diploma courses as well as some free courseware which is available on their website. You could refer those, and I'm sure that will be helpful for you.
Mhm. So Mansi, if you could take this like cost of Indian patent and what's the difference? I think you even mentioned this in the pre-event, and difference between
Yeah.
Indian and US patent.
Okay. So first okay. So this question is asked by Jyoti. So I'll answer to the question, the second question first. That what's the difference between the Indian and the US patent? So first you have to understand that every country has its own law. They have a different patent law, and the patent right is a territorial right. So the difference between the Indian and US patent will be the patent which is granted by the Indian authorities is a Indian patent, and which is being granted by the US authorities will be the US patent. And you have to file a separate application in different countries to secure a grant. So if your invention, you feel that you have a commercial market in a country, in any country, like for example, if you have a commercial interest in US, if a commercial market in US, then you have to file a separate application in US. It's not that you file a patent application in India, you got a grant over there, and you cannot market it and you cannot sell it in US. You have to secure a grant. You have to file a patent application in US separately because there are different laws. So that's the difference between the Indian and the US patent. Now, what's the cost of Indian patent? The cost of Indian patent depends upon what kind of entity is filing the patent. So we have a different government fee for different entities. Like for the startups, it's different. For multinational companies or the big organization, it's different. So if I talk about the particular cost, so there are various stages to secure a grant till the time you secure a grant. At the time of filing, you have to pay a particular fee. Then at different stages of prosecution, you have to pay a fee. So roughly, if we talk about considering that I'm talking about the startups or the individuals, then the fee is the filing fee 1,600 for a specification, which is having a 30 pages and 10 frames. Then there's a fee. There will be fee for filing a request for examination. Then there will be fee for after the grant you have to maintain it. So that will be the total cost. You can check the patent rules. The first is fee for particularly checking the fee status. What it is. So roughly, it will. If I'll talk about, then the cost of an Indian patent will be till the grant, it will involve the government fee. It will involve the agent fee if you're hiring an agent. So you can check the first dispute to check with a particular entity fee what it will be. So that's the answer to the question.
Yeah, we have a question by Amita Agarwal. So Shuchi, if you could take this.
Sure. I read the question, which is a new raw idea has to float along. What all steps to reach granting patent? Also, agencies which can help along those steps. Can you briefly summarize? Sure, Amita. So, if you have a raw idea and you want to really file a patent application, the first step is a recommendation is that you should first get a patentability assessment done, whether your invention is patentable or not. You can reach out to any IP attorney, or if you want any kind of governmental help, there are different patent facilitation centers, which are called also PFCs, which have been set up by the government, who you can approach, who can help you with this kind of an assessment. If post assessment it comes out that you can go ahead and your invention is patentable, you can file an application. The next step in order is drafting of the application. The person who is an expert who understands the legal and technical intricacies of the patent law should be able to help you with a draft of the application. You file the application, and then thereafter the prosecution is with the Patent Office of India if you happen to file the application in India. The patent office is going to publish the application, examine it, and then give a decision. So you could reach out to any attorney who is specialized in this. There are quite a few out there, or you can reach out to government support by way of PFCs who can help you possibly with the same. Or if you are actually associated with a particular company or an institute, you could check within. There would be somewhere an IP cell or an IP person who's responsible for taking that up, and he may be able to help you with the same. I
I
think,
would
So
just
yeah,
Dr.
like to I would just
Sorry.
like to add to this.
Sure.
Sukhdeep explained that quite a detail, but there's one more thing that there are many incubation centers also, which which helps to further conceptualize your ideas, and they help you towards taking the further steps towards granting a patent. So there are different agencies like Shuchi has mentioned. The PFCs are there. Like PFC, you have NRDC also. They also provide support, towards getting filing the patents towards the grant. And apart from that, even though we have the test centers also, which are established very recently into 2019. So we have total 9 test centers which are established by WIPO, where they do provide, they do assist and they do provide uh, help in conceptualizing your ideas further, and they assist you towards the grant of a patent.
yeah, yeah. This actually also answers one other question, and but I'll put this on screen. What is the minimum time taken to file the patent? Is there any stats like 2 months, 6 months, something like this?
Actually, to file a patent, this is dependent upon the person you're
Uh-huh.
working with. You can only
It is
talk
fine.
about and qualify the time it takes from filing to grant, which is more objective. So, if you take an expedited procedure, it could be within 1 year, and a normal course generally takes about 3-4 years to get the patent. But if you're talking before filing, which means the preparation process, that is absolutely between you and your attorney who you're working with in terms of the backlog, in terms of to and fro that you guys do in finalizing the application. So it might vary, I think, from people to people, but let's say if both of you are prompt, from 20-25 days to maybe maximum of 2 months period is what I would expect.
Right, right. So, Ankit Kargati, any comments on the latest Sci-Hub case, which allows to open any published paper on their site? Is it the violation of copyrights of the publishing house? Do you know about this case?
I'm not a copyright expert, but I have heard about this little bit. So, if I give my comments, I'm not going to be held liable for it much because I haven't gotten into the details. But yes, I did hear this Sci-Hub case. Sci-Hub, as all we know, they publish a lot of these research papers free of cost, which otherwise are available in journals which are fairly expensive, etc. And the battle is on for this only. The fact that they have gone ahead and published something which ordinarily is available for a particular fee. So there is copyright violation to this. I don't think there is a particular decision that has come out to it whether there is a violation or not. But I think both the sides are maintaining their plea. One saying that this is a copyright violation, you don't have explicit approval. And Sci-Hub is taking the course or the remedy under the copyright law, which says that if you are using information for education, for scientific details and all, then this is not really a copyright violation. So let's see what the outcome is. But to the extent Sci-Hub is not making money out of it, there could be a possibility that they may have some stake at least to have their way. But let's see what the final thing is.
Okay. Dr. K. Raghav Rao, he wants to ask a question. So Mansi, could you take this? IPR professional charges varies in the market. So how to choose an IPR service to be successful IP grant?
Yeah, sure.
So
So it's entirely, it all depends upon the client's choice. I mean, he can choose any of the IPR professional, and it all depends upon. I mean, the professional charges depends upon many. There are many factors to it. It depends upon how big the firm is, the experienced professional, what kind of services you want to sort. You want to sort of, what kind of it all totally depends upon the choice of the client. The prices depends upon what kind of services you want. Like suppose in case when the inventor approaches to us, some of the inventors they are particular that we don't want to have this much of funding for filing the patent. We want specification drafting in certain amount. So it all depends. So some IPR experts, they do provide services under that particular amount. However, some attorneys, they do not. So it all depends upon. And to answer this question that IPR professional charges, yes, it varies in the market, depends upon many things. So how to choose an IPR services? What I suggest is that you choose a registered patent agent. You can check the register of patent agent, which is there's an e-register which is available on the IP India website. You can check the number of year of experience. There's a proper registration number being given to the registered patent agents in an order of qualifying the examination. So you can check the details from there, and accordingly you can choose. I mean, whosoever you will feel like, and upon the market reviews also you can choose.
Yeah.
Just one more thing, Rahul, I'd like to add. I think Mansi has touched upon a few points, and a few more that you could consider also is, yes, I think registered patent agent number is important. The number of years of experience is important. But something that is absolutely black and white for you is you could also ask for certain specification samples. These are all available in public domain. So you could check out those if you think by reading those, by understanding those, you would be able to get some assessment of the quality. And I think also referrals do help because also gives you an idea about the in-depth understanding of the issue that a person shares. In total, I think there are a lot of objective factors that you could try and take up with.
Yes, of
Yeah.
course.
By Dr. Chetan Kumar Patel. So if you could take that, Shuchi, I mean, I
Sure.
would like to know about the patent grant for academia. What is the amount we get from various agencies? Who will draft and answer FER, SER? Will the patent attorney be paid by the agency?
All right. So, when it comes to academia, my understanding of academia is that mostly, and in fact, if you look at now the latest draft guidelines by CPAM and all, the colleges are supposed or the universities are supposed to have their own IPR cells. So, if there is established IPR cell, the relevant professor, researcher, whoever the case is, should reach out to their IPR cell, and they would be able to let you know who's going to take care of the efforts or the funding related to it. They do get funding from various sources, from the government schemes, etc. But then, if you are directly dealing with your IPR cell, I think the funding part is not your worry. It is their worry. The only thing that they're going to decide is whether they're happy to fund your project as such and take this up as a co applicant for the university or the college. But if let's say they refuse, then in that case, it is your own individual project which you could pursue and go ahead and file a particular patent application, etc. So if this is a project that has been taken up by your college or your university, then they are the ones who are responsible for responding to the office actions, which are the examination reports, hearings, etc, and they take care of the attorney fee themselves. But if it is on a individual basis where you yourself will be sponsoring for this, there are different, and I think Mansi had touched upon a lot of those before in while addressing one of the questions. There are a lot of help or funding schemes available which you can reach out to for getting funding for your particular patent application, and they also specify what nature of fees are they funding, whether it is for a prosecution which entails examination, drafting of an application, a hearing, or whether it is that once the patent is granted they give you lump sum and reimburse the entire thing. So I think this you will have to check with the IPR cell if they're taking up your project. If not, then this is on personal basis.
Yeah. Dr. Amit Kumar Tiwari is giving us some words of appreciation. Thank you so much. And he has a question too. Actually, I'll hand over the host to Shreya for 5 minutes. I'll facilitate another session and come back. So,
Sure.
I'm around, but just, if you can see these through these last questions, and I'll be back in like 2-3 minutes.
Sure. It's a delighted experience to actually be with you, all the viewers. We are really flooded with questions, very, very interesting and insightful questions, and actually relevant to the topic. So much thanks for being participative. Thank you. Rahul, we can't hear you.
I think he left.
Yeah, Shreya is going to join to moderate. Maybe we can take up a question ourselves.
Yeah.
Meanwhile, so there is a question that I see from Jyoti Prakash. What is that public domain where we could find details of an attorney? So see, there is no particular except. In fact, I'll take my words back. The Indian Patent Office has a list of facilitators from where you can check out the people who are impaneled, and you can. There is a number also shared who you can reach out to, but not every attorney or most of the attorneys are not registered as facilitators. So if you do a normal search on Google, you should be able to come up with a lot of choices and you can make your own decision after going through various criterias. Maybe Mansi, you can take up another question.
Of course.
Can we get, okay, so there's a question by Mr. Rudra Senapati.
So he's asking about, can we get the email of the panel expert to reach out them with more queries at any point of time? Yeah, of course. We'll share. I mean, we'll share with you.
Okay, so I think the next is highlighted, which is of Sri Kumar. Is there any different procedure when the same is applied for second time? I am not sure if I am able to follow the question very well, but I think what you're saying is if you apply for a second patent, is there any change in procedure? Every patent goes through the same procedure, and if a single applicant or an individual is doing multiple filings, that does not elaborate or cut down the procedure steps by any way.
Okay. Taking up on next question, which is being asked by Mr. Shri Kumar K. I applied for patent. In the process, it has been rejected due to draft error. Can I apply again the same after doing necessary correction? So the answer to your question is, since you have already filed it and it has been rejected, that means that the application was examined. So your application, what you have filed, which is being rejected, it is already in the public domain now. So if you cannot file it again, you cannot file the same again, because if you'll file the same again, first of all, it's been already being filed and it's been already being rejected. So there is no point of filing it again with the correction. But yes, if there is a modification into your invention, then of course you can file a fresh patent for it.
Just one more thing, I think Mansi, he may also be meaning that rejection by way of an examination report. Because a lot of the times there are people who come to me and they say that the patent was rejected, but essentially it's an examination report. So if
Yes,
that
that's
be the
what.
case, right?
Yeah, that would have considered because it has been rejected just because it would have been rejected after the examination report has been issued and he has been filed. So rejection has been received it. So yes, in that case, and he has said that due to the draft error and the same after doing the necessary correction. So
Okay.
what I'm getting from this question is that he wanted to apply it again, the same invention by correcting those errors on the basis of which it was rejected. So you cannot do
That's
that
not
because
possible.
yeah, that's not possible actually because it's already there, it's being published, it's already there. And if in case if you file it, then it will act as the previous application which was rejected. That will be raised as prior art for your application.
Right.
So, folks, if you can just tell me which question we were at, we can.
So we have taken up the
I
question. Oh yeah. Now there's a question from Purnima Chandran now. Shuchi, you can take if you want.
Sure. How does one register like a patent facilitator for freelance patent agents? Well, honestly, this is a very intriguing question. I myself wouldn't know how would you register as a patent facilitator. But what, because there are timings when the patent office actually issues a particular notification that if you are a registered patent agent, they will help you apply. But is that open always? I doubt that. So currently, I don't think this is again available, but you can keep a tab of at the Indian IPO website, and if they have an enrollment session again open, you could apply at that particular point in time.
Yeah.
There's a next question from Jyoti Prakash Rath. Is it not that patent bar poor public to access the data? Is it not that patent bar poor public to access the data? I am not very sure if I understand the question well.
And the same goes with me. I'm not getting the question. What exactly you wanted to ask?
I think also there is a question by Dr. Tiwari. He said, my question is slipped, Rahul. We request him
I
to
think
post again.
I think I posted this question, or did I not?
No, I think this was left. He's correct.
Okay, then I think it's this one.
Okay.
So could you take a crack at it, Shuchi? Like, what are the strategies to?
How is okay? So I'll just read out the question. The question is of Dr. Tiwari is, how is academic knowledge and technology transferred and monetized? What are the best strategies? So number one, how the part about how is academic knowledge and technology transferred and monetized? Um, See, again, I think this has got two facets to it. One, if I'm talking about academic knowledge, which is being dealt with the IP Center, which is the centralized body for the particular academic institute, they, in the IP Center that they have, they would have their own guidelines which will pertain to commercialization of any and every form of IP they hold. Now, they would depend also on the nature of IP that they hold, because if, let's say, this is a completely funded research or the invention by the university itself, they would 100% have their own guidelines of how they would want to commercialize the patent to the private companies who are going to reach out to. If it is a co-joint project, which is co-owned by the university as well as, let's say, by a private entity, then the commercialization is going to be equally available for both of them to exploit the patent. They could both license out, they could both get into an agreement, or if they both agree to together, they could even sell that out as way of commercialization or monetization. Largely, the strategies that we can talk about is to make money out of patents. One is assignment, where you decide that, okay, you have a patent granted in your name, and now there is a party that is interested in taking it forward, and you want to sell that patent off, which is largely also called patent assignment, complete transfer of the ownership, and you get a lump sum payment out of it. The second strategy is license, where you have one or multiple people who are wanting to take license for your technology, for what you have a patent for and any associated trade secret that you may have, so that they can realize the product or the process related to that particular invention. Yet another could be, again, I think that will also take form of licenses only, where you can have certain checks and balances as to what terms you're giving, what is the kind of jurisdiction where this can be done, what is the term, what is the kind of nature of royalty payments, etc. I think so. These are the broad areas, because universities typically, the third option which is there, don't enter into that, which is self manufacturing of the same, right? They end up licensing. In my experience that I've seen, I would say that assignment is more common when it comes to universities as opposed to licensing. But if yes, with this increasing public-private partnership or increasing industry-based research partnership with universities, I do think that license is something that will pick up as well. Mansi, please feel free to add.
Yeah, no, it's been well described by you. I mean, you have covered everything very
Thank you.
nicely.
So I'm thinking if we can take the last one or two questions, and somehow after the end of the event, I will try to share the contact details of our panelists to the attendees. So in a post email, in a post event email, I will send up this information, but that will be on Monday because people are getting a lot of emails. So yeah, so if you can say, have any final words based on this question, because I think this question kind of even symbolizes the whole idea of a patent, right? That it has to be commercialized one way or the other. So, I mean, Mansi, would you have any last comments on, how to make a patent commercialized?
Okay. So, so the question you're asking me to deal with this question, Abhijit Pokle has asked. about how important to make patent commercialized, right, Rahul? Can you hear me?
Yes, yes, we can
Okay.
hear you.
So the Abhijit was asking the question that how important to make the patent commercialized. So it is actually the purpose of patenting any invention is to commercialize it. Otherwise, I mean, it's a property which you're holding with you. So there's no point if you're not commercializing it. So it's really very important to commercialize it so that you can you can whatever you have invested upon your invention and what experiments you have conducted and whatever you have put in your inventions, you can get the rewards back out of it. So commercialization is an important part, and it is really important to commercialize it so that you can make the things out of it. You can sell your product, you can make revenue out of it, and you can make a good life out of it. So that's how the whole idea is. The to to secure a patent is not just that कि आपने patent file कर दिया and you're not getting any revenue out of it. Then you have wasted that amount on filing the patent, securing the patent by the process of prosecution and everything. So basically, the whole idea of patenting any invention is to commercialize it so that you can generate the revenues out of it and you can use it. So that's why it is important. It's really important to commercialize your patent. Okay,
We
Shruti, would you like to add into it?
Sure, I could. So there are a couple of pointers. There could be certain scenarios as well where you may not want to commercialize and you still want to take a patent. I have dealt with a few so far in my career. So sometimes there are needs where you need a patent application for branding purposes as well, in the sense where you can actually show that your technology is better. You may not be directly reaping benefits by way of exchanging money with somebody, but for particular labeling purposes or by establishing that there is a particular product that is better than the other or it has got better proprietary technology. Yet another business decision that could entail for filing a patent application, which may or may not commercialize later on, but was important to file at a particular point, is if you're looking for, let's say, a venture funding. Because a lot of the times, people who want to invest or who want to fund you for your further work and to let your company grow, right? This is not about a specific patent, but this is about business development. For you to expand your company, they require that they have a firm basis to bank on. And then they might ask you that you should have a patent. So while you've not directly commercialized by way of a license or an agreement, but you've just had a patent which would help your VC or a funding agency to give you more money so that you can develop further products, expand your business lines, etc. That could also be. So there could be certain business cases as well where you could go ahead. But largely, if you have a patent in hand, and a patent is an instrument where every year you have to understand you have to shell out money. Because if you don't pay a renewal fee, it is going to lapse. So for you to take a business decision that in your balance sheet, if that helps you to just show a particular expenditure by way of renewal fee, or would you be wanting that at the same time you recoup by getting some inflow of money? That's also a call that you'll have to take.
I think the working of the patented invention is also very important to consider. So,
Correct.
yes.
Rahul, we can't hear you.
You're
Rahul,
on
you're
mute.
muted.
Right, right. So thank you so much, Mansi. Thank you so much, Shuchi. It was really indeed insightful, and I'm sure the audience has some takeaway in terms of whether it's grants, whether it's the opportunities that are out there. Mr. Munazzar Ahmed has also answered a question, so that's the great thing about YouTube, that even the community
Yes.
can help. Thank you so much, Munazzar Ahmed. Yeah. So folks, with this, we will end this session. Again, thank you to the panelists. We will get back to you, the audience, via the post-event email. And meanwhile, have a great afternoon and have a great weekend. Thank you so much.
Thank you
Thank
so
you.
much for moderating so brilliantly well, Rahul. And thank you, Mansi, for being a great co panelist, and the audience. Thank you so much. I hope you all had a great session.
Thank you, Rahul. Thank you, all the
Thank
viewers.
you.
Thank you so much.
Bye.
Thank you for having
Bye.
us. Thank you.
Thank you. Bye-bye.
Bye.
Bye.